Welcome. Before we begin our normal call of the calendar, we want to acknowledge that this is Justice Singh's last sitting, as he's going to be retiring in April. It's his last sitting as an Appellate Division Justice in the First Department. We are all going to miss his intelligent, incisive, and thoughtful analysis of the many varied legal issues that come before us. We have so enjoyed having him as a colleague and a friend, both here in the First Department and before that in the Supreme Court and the Civil Court. Justice Singh's long and continued presence in our court system has truly been a gift to all of us. He has been a judge in our court system since 2002, first as a civil court judge, then as an elected Supreme Court justice, and most recently since 2017 as an Associate Justice of the First Department Appellate Division. When he was appointed to the Appellate Division in 2017, he became the first South Asian person to sit on a state appellate court in New York. I and a number of other justices at the First Department, including Justice Garpula, who's on the bench today, and Justice Oing, who recently retired from the bench, and Justice Moulton, who was with us every step of the way, had been on this journey together with Justice Singh through every step of this process, from being court attorneys together in Supreme Court to getting elected as civil court judges, and then getting elected as Supreme Court justices, and then getting appointed to the Appellate Division together in 2017. Through every step of this process, I have consistently admired and respected Justice Singh as an excellent jurist of the highest caliber, and I've also counted on him as a friend, which he has always been. It will not be the same here without him. Justice Singh.
Thank you, Justice Kern, for those really beautiful words. It's been my privilege to work alongside the most dedicated individuals in the judiciary, and I will forever be grateful for their support and wisdom. It's been my honor to contribute in some small part to reason and justice. Thank you, all you attorneys who appear in our majestic courtroom. Your advocacy makes this department to be a preeminent intermediate court in the nation. But my greatest appreciation is for the Appellate Division First Department community. Your hard work makes the justices on this court look good every day. It is this community that I will miss the most, but thank you very much.
Okay, back to the business at hand. We are familiar with your briefs and your records, so please ask for the time that you need, not the time you wish. And if we have further questions, we will keep asking. People versus Brown. Appellant? Submitted. Goolsby versus City of New York. Appellant?
Lawrence Spazovich, request 4 minutes in opening and 4 minutes in rebuttal.
Respondent request 5 minutes, Your Honor.
4, 2, and 5. A. Kaialia is submitted. Manigault versus Board of Managers.
Good afternoon. Appellant request 4 minutes to argue, 2 minutes to respond.
I don't think anyone else is coming, so they didn't even request argument time.
They're not going to be here, then I will not argue.
Okay, you want to submit it? Okay, submitted. Unless anyone has any questions they want to ask. Okay. There are 2 WDF cases. They're each going to be argued separately since they involve distinct issues. So the first, WDF versus City of New York, which is the appeal by the city. Appellant? Respondent? 62. Well, you don't have a cross appeal, right? 5 and 2 and 6. And now the second WDF versus City of New York, which is WDF being the appellant. Respondent? 6, 1, and 6. People versus Vasquez. Appellant? Respondent? 7, 1, and 5. Rent Stabilization Association versus McKee. There's a cross appellant, so
Yes, Your Honor. Scott in on behalf of responding across the
okay. Do you want to go after?
I will go after the
Okay.
5 minutes for the respondent.
Okay, 5.
That's McKee and 10 is back.
Right, 5, 2, 5, and 5. Dart Seasonal versus City of New York, appellant? Okay, that is submitted. Cruz versus PMG Construction, appellant? Respondent? 5, 2, and 5. Orlitzky versus 33 Greenwich owners, appellant? Respondent? Is there a cross appeal on that? There is. Okay, 3 and 3 and 6 and 1. People versus Trowell? Appellant? I'm sorry, what? Respondent? 4, 1, and 4. U.S. Bank versus Almy Funding, appellant?
Good afternoon, appellant request 6 and 2.
Respondent? 6, 1, and 5. And West 108 Development versus Noor Foundation is submitted. So our first case will be Gouby versus City of New York.
Good afternoon. May it please the court. My name is Lawrence Spazovich. I'm here on behalf of the plaintiff appellant seeking an order reversing the trial court's order dismissing the appellant's claim and complaint based upon CPR A1, A5, and A7. The first basis which plaintiff appellant would like to address and will address quickly is the dismissal based upon timeliness. Here, the Court of Appeals has long held that these claims brought under the New York State human rights law and New York City human rights law are not subject to Article 78 review.
Counsel, let me ask you about the merits. We've had a number of cases now with these COVID-19 requirements, and we've addressed these issues many times before, and we've held before many times that the process for reviewing accommodation requests are sufficient to satisfy the cooperative dialogue requirements, starting with Marstella and a number of other cases. Why don't those line of cases control the outcome in this determination?
Well, Your Honor, as those courts have held, the procedure was okay, but in this particular instance, plaintiff appellant is attacking the substance of that review. The documents that have been submitted by defendant respondent in opposite and their original motion clearly show that the defendant respondent did not act in good faith and follow those procedures set forth in Marsteller. The first issue that comes up as demonstrative of their lack of good faith is the fact that it was Mr. Eichenholz, who was an attorney at the New York City Law Department, who made the determination that arrhythmia was not a reason for not receiving the COVID-19 vaccination. However, the medical documentation submitted by Dr. Galluccio in this particular stated that there were 2 reasons why he should not receive the COVID-19 vaccination. The first one being that there is a potential for arrhythmia and myocarditis. That is the first instance. It's clear that Dr. Eichenholz...
Are you just disagreeing with the result they reached, though? You're saying he didn't get the correct process.
He didn't get the correct process, Your Honor.
How did he not get the correct process?
Well, the second issue was the fact that he was not afforded an appeal, which the courts in Marsteller have clearly said is part of that correct process in order to identify whether an accommodation has been met.
So when there was a denial, you had the right, or your client had the right to bring in Article 78. Wouldn't his due process rights at that point be addressed in that fashion?
Well, in this particular instance, if we want to look in the employer determination context, when the plaintiff appellant submitted his physician's note, they sent him, the next action that the city took was to just deny it without further leave of appeal. Now, at that juncture, as the courts in Ramos had dictated, yes, an appellant can bring a 78 if they
So on the
choose.
merits, how did you show a nexus between the opinion expressed by Dr. Galluccio in his letter and the risk and that this disability should exempt you from the vaccine mandate?
Yes, so Dr. Galluccio spells that out in his letter, that there were two concerns of a potential death-inducing heart incident that it could occur arising from either arrhythmia or myocarditis. And therefore,
But there was no actual diagnosis of myocarditis, correct?
well, it's a larger diagnosis of his ultimate disability that he may have, which is Wolff-White Parkinson's syndrome.
Right, which it's a circuitry issue, a heart circuitry issue, but still, you have no confirmed diagnosis of myocarditis that was presented in the record, correct?
Well, that's correct, Your Honor, but
And what also was interesting is that when you first sought an exemption, you didn't even claim this disability. You claimed that your client had a high protein immunity and that you were seeking a religious exemption as a member of the Dutch Reform congregation. So couldn't it be perceived that this medical disability is really born after an afterthought?
you know, in these particular cases, when we're looking at an A5 and an A7 motion, Your Honor, or an A1 and an A7 motion, you know, the burden here is to draw every favorable inference in favor of the plaintiff, right? And see if it fits into a legal theory. Here, understandably, there were some prior accommodation requests made. However, this one is a physician's note submitted by Dr. Galluccio, who is a physician at NYU Langone, who at
So, and counsel, so, and under the guidelines, right, what the accommodation request was, didn't cover, was not considered something that would afford an exemption from.
well, that goes to the second point, Your Honor, that I'd like to raise as far as the good faith
You know what, I'm
process.
going to let you do that on rebuttal.
Yeah, yeah.
Okay, I'll address that on
We'll
rebuttal.
address that first thing on rebuttal.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Philip Young here on behalf of the city.
So what about that, counsel? Your adversary seems to be arguing this is a it's a plenary action, and the normal rules regarding a motion to dismiss, granting every favorable inference to the plaintiff here. What about that?
I think even under the motion to dismiss rules in a plenary action, there's no difference here. First of all, in the cooperative dialogue, as far as how you analyze that, the question is whether the procedures set out by the city are sufficient under this court's holdings in Marsteller, Lynchley, and all of those other cases. And there's really no functional difference between Article 78 and the motion to dismiss context and how this court analyzes that type of claim. It's really exactly the same thing. Did the city follow this procedure and engage in a cooperative dialogue? When it comes to the failure to accommodate claim, there are two points there. The first point is that this complaint doesn't even allege one of the key elements of a failure to accommodate claim, that this employee could perform the essential functions of his job with a reasonable accommodation. That allegation is simply absent from the complaint. And then second, as Your Honors have noted, the city produced documentary evidence conclusively showing that he didn't qualify for a medical exemption under the city's guidelines, which were based on expert guidance from the CDC about what constitutes contraindications to the vaccine. And then I just also want to briefly turn to the motion to amend question. It's an abuse of discretion standard here. Supreme Court did not abuse its discretion in denying leave to amend. If you look at the proposed amended complaint, it doesn't do anything to cure the defects in the original complaint. It restates in more detail a lot of the factual allegations that are already reflected in the city's documents that it put forward in its initial motion. and the Supreme Court already had those facts when it considered the initial motion to dismiss. He added state HRL claims. Those are entirely duplicative of the city HRL claims here. And then he added some additional allegations about supposedly being able to work from home and perform all of his essential functions. And as we noted in our brief, those allegations still aren't enough to cure the defects in this complaint because they don't put the city on notice of what his job was, what his essential job functions were, and how he could perform those essential functions remotely.
Thank you.
Thank you.
So first, to address Your Honor's question on the opening statement, an examination of the city guidelines actually shows that had the defendant respondent, the city, engaged in a good faith review of the doctor's note, they would have saw that not just arrhythmia, but myocarditis was also a concern that would have entitled him to maybe not a full accommodation, but a temporary one. But since the city did not, in good faith, substantively look at this examination and did not afford him an appeal to advocate.
Well, right, his Article 78 proceeding is his appeal, right?
I'm sorry, Your Honor?
He has the right to make all those arguments here, and then he made them all below, right?
No, Your Honor. As part of the Marsteller process, they have to afford him an appeals process before proceeding to an Article 78. In this particular case, they did not afford him an appeals process before proceeding to an Article 78, and therefore, because they did not examine the physician's note properly, they would have noticed, had he been able to appeal, to say, oh, I see myocarditis is something that would entitle you to at least a temporary accommodation, maybe not a full one. But that's demonstrative of the fact that the city, in this case, lacked the good faith necessary and is what the law requires. To address quickly respondent's point on the claim and not providing the city notice, the standard here for all pleadings in the state of New York on the state level is notice. Got to provide notice. And here the complaint and the amended complaint both do that. They both say here in this particular instance, the plaintiff appellant worked from home. He performed all his duties from working from home. He did it without any accommodation, without any reprimand or disciplinary action, and therefore could, with an accommodation, continue to do those with the
Thank you.
with the work from home. Thank you.
WDF versus City of New York.
Good afternoon, Your Honors. May it please the Court, Alina Drucker on behalf of the city. Your Honor, the Supreme Court erred when it found that the city had breached this contract by
I'm
not...
going to ask you a very,
Of course.
not surprising, but unusual first question because it's a very specific question. If we do find that they, WDF, are entitled to summary judgment on the substantial completion, but not on the entire contract amount, which is one of your arguments, can we definitively ascertain from these papers what that amount is that WDF would be entitled to for substantial completion without being awarded the complete contract? Because I know you've stipulated what the complete contract amount would be.
Yeah, and as a clear prefatory, obviously the city doesn't believe that it breached the contract, and
I know,
I think the answer would
Assuming you
be...
lose on that issue and that we find summary judgment should be granted on substantial completion, but not on complete amount. If we come to that result, can we figure out from the papers what that amount is?
No, Your Honor, I think you would have to remand in that case
Why?
because substantial completion, as is outlined in the brief, substantial completion is a penultimate payment before the final payment comes in. It's not the final payment. There are retainages, and some of those retainages are required for the closeout requirements. Some of those are actual physical completion of the work, but some of those are things like complying with the MBE certification requirements.
But you have, in terms of final payment, you have a specific amount that you agree was due, and you have a specific amount as retainage that you agree is due. So is the retainage on final completion different than the retainage on substantial completion?
Yes, well, so the penultimate payment would be the final payment minus the retainage. The retainage itself is the amount, according to the contract, that the city deems necessary for completion of the work, including submission of the closeout requirements.
So under,
I'm sorry, why do we need to have, because you're suggesting that if they win on summary judgment of substantial completion, we still need to have a hearing on what that amount is. Why can't we know with certainty, and I'm going to ask the same question of other counsel, why can't we know with certainty what that amount is at this point? I mean, the contract's 5 years done, what the substantial completion amount would be.
So there's the question about the physical work being completed, and my understanding is that the project physically is done, but that the paperwork is not done. The WDF has not submitted.
You're not answering the
I'm
question.
not asking you a merit-based question, I'm asking you a factual question, which is a computation question. What is stopping us at this time from ascertaining what the substantial completion amount is, what the dollar amount is?
I think that the contract has several provisions, and I suppose it is possible to calculate that amount. It's 1% that's supposed to be kept in escrow. There's other parts, but
I'm, just to follow up on what my colleagues are saying. The first cause of action, and I'm going to round up the numbers, the first cause of action, the complaint, sought approximately $5 million plus.
yes.
That was in the complaint, allegedly as a substantial completion payment. Then there was a $4 million and change figure that was recorded in the penciled draft requisition.
The pencil draft was the 5 million and change request.
Oh, well, then they ultimately,
They didn't.
there was a reduction of about $1 million, correct?
Over the course of this litigation, there have been, discussions where they've admitted they
But
were
then,
less, yes.
but then at oral argument, the counsel for WDF, in response to Justice Barak, said, this is a straightforward case. We are seeking, as a substantial completion payment, $1.4 million. That's what it said in oral argument.
1.4, no, I don't think.
Well, that's what the
Well, that's what it
transcript
says in the
shows.
transcript. We'll wait for you.
4.4. I mean, that's the full contract amount. So that's
It's a
what you-
typographical error, you're
it's a
saying.
typographical error. The 4.4 is the full contract amount. That is the total amount due on the
Oh, so
contract.
that was a mistake in the transcript?
Yeah, that's a
I
mistake.
guess that's what we're hearing now for the
Oh, yeah.
first time.
No, they've never asked for for a subset. They've only ever asked for the full total contract amount. And we've said, we cannot give you the whole contract amount. It's in their, the ball is in their court. All they have to do is submit the MBWE paperwork and the payroll certifications that show that they complied, assuming they did, with the labor law. And they would be entitled to the full payment amount. The city's not withholding this money on some.
So let me ask you this, is that was the argument below, correct? You were saying that we don't have the paperwork to pay the final number. We
We don't-
agree on here, we have an email which is a statement against interest saying, here's the number, but we don't agree that you've done what you need to do to get the payment, correct? And did the court below ever make a finding as to whether or not all that you claimed needed to be done was done, entitling that party to, because I didn't see it in the oral.
What I think is that the court below was a little bit confused and conflated the terms required for closing out the contract versus the terms required for substantial completion. And the substantial completion, the thing that was missing was just a requisition. So there was a point in 2020 where they submitted some draft paperwork, they talked about numbers, and they said, look, the city responded, hey, that's premature, we need the final extension of time. That then was approved, it's in the record. They filed in March 2021, it was granted in May 2021. They have this final extension of time, and at that point, they could have just requisitioned the substantial completion.
Okay, so
There's
that's our
no
question.
dispute as to substantial?
Well, the dispute is that they never requisitioned it. So the city wasn't in breach because they didn't requisition it. By then, they'd already sued. And rather than just submit the request, they tried to litigate it. And then they tried to litigate it, and I don't want to put anyone's, but they would not be able to obtain the full contract amount without submitting the MBWE paperwork because the city needs it for reimbursement.
So then let me go back to the Justice Kern's original question. If everybody agrees that they're at this point entitled to the 80%, the substantial completion,
have to submit the
could we here in this record determine what that number is? Because we're trying not to, as you can see, we're trying not to go back. We're trying to go forward.
I understand. I am not myself an expert in the computational
There's
work
no
of the contract.
number in any of
The
the
contract
documents.
has some provisions for how you back into the substantial completion amount.
Okay, let's-
But those are
let's-
negotiated
Let's hear
within
from-
each
Let's
case.
hear from WGF, since your time's up anyway, and let's see if they have another answer to that question or not.
Good afternoon, Your Honors. Mark, may it please the court, Mark Canizio for the respondent WDF. I mean, I think you have the issue well honed in. The summary judgment motion was for the substantial completion payment,
So what
which
is
is this
that amount?
number,
Isn't that what the parties
$4,447,000.
agreed is the full contract amount?
So
I mean,
as
the
it
parties
turns out,
agreed to a full contract amount.
so as it turns out, over the passage of time, that became the full contract amount.
Wait, no, but
But
let's say we accept the city's argument. The city's making, first they're arguing you're not even entitled to substantial completion, although they don't seem to be arguing that very strongly today. But then they're also arguing you're not entitled yet to the full contract price because the closeout documentation has not, still to this day, has not yet been provided. Let's say we agree with that, and we think you are entitled to substantial completion, but not to the full contract price. It can't be one and the same, because there are retainages and other things that are held back. So how do we would we determine then what the substantial completion amount is versus the full you're just giving us the full contract amount.
So there is no amount of money that is identifiable as to, what this piece of paperwork might have been worth to the city versus the
No,
substantial
not, we're
completion
talking about the
We're asking.
retainages and all the money that they were entitled to hold back until you completed and did all your paperwork, right? It's certainly part of it is that we're holding this money back to make sure you do your paperwork. So that's the question. Is there the ability to find out that number?
I don't believe so on this record, Your Honor.
We would have
And
to
the-
send it back down. If our ultimate, and we're not saying that is our ultimate position, but if our ultimate position turns out to be that you're entitled to substantial completion but not final, we would have to remand for a calculation of that. Why?
so
Can I just
just on
ask why
this-
you aren't doing the paperwork?
So
Why?
just on this issue, first of all, the issue of MWBE compliance was never raised in the court below. The issue of payment of prevailing wages was never raised in the
Right,
court
but
below.
you brought the action for, you have a catch-all, but you really brought it for substantial completion payment, and that's what counsel said on the transcript. We're here to get the substantial completion. This really was not an action to get the full contract price.
Was that you who argued below?
It was me, yes.
So
Your
when you
Honor,
get
who
up
argued
and
below.
said, this is pretty straightforward, we're seeking the substantial completion payment,
And that's what the amount was, Your Honor.
how
For the
could that have
It can't be
been?
one and the same.
That's the
What
amount.
amount is that?
So $4,479,472.
That's final balance amount. By the way, there's a slight discrepancy between what you say and what the city says, and your number is lower than the city's number. But if that's the final completion amount, how can that also be the substantial completion amount?
Because, Your Honor, at the time of this motion for summary judgment, and frankly, at the time of substantial completion, it was incumbent upon the city to identify what work, if any, remained, what punch list work, if any, remained,
Counsel, the
and
city.
what the value of these things
The city made a
was.
very clear argument in their papers. Their argument is that you're not entitled to the entire contract price at this point because there are closeout requirements for any city contract, and you have not yet submitted the paperwork that's required for the closeout requirements, and you're not entitled to get the full contract price. What is incorrect about that? Are you arguing that you have submitted all the necessary paperwork? This is not about getting the work itself done. It's about complying with all the requirements.
So first of all, I would argue, until you get the substantial completion payment, you can't submit that last piece of paper
You
that
won't
says,
even tell
"This
us
is
what
I
it
paid."
is. You're saying it's one and the same. You're telling us today that the substantial completion amount is the same as the final contract price, which doesn't seem to make much sense.
To the extent it was different, it was incumbent upon the city at oral argument in opposition to the
it's
motion
your
to
motion.
identify.
motion.
Your motion,
Was.
your motion.
You are seeking this $4,400,000 or so.
So no.
In Supreme Court on substantial completion, and now you're telling us today that it's also the amount of final completion, and substantial completion is supposed to be only 80% of final completion.
not necessarily 80%, Your Honor. The withholding could be as little as 1%.
Well, the 1% was only for the final amount 1 year after the payment. That's very different than the double retainage sum. Isn't the retainage supposed to be 2 times the substantial completion?
It could be 2 times the value of an open punch list. But again, no one came forward and said, we're going to hold back X amount of dollars for this or Y amount of dollars for that. In addition to which,
Aren't you telling us today that even if we want to grant you summary judgment on substantial completion, on this record, we're not able to?
I don't believe that's true, Your Honor. I think it was incumbent upon the city to come forward with whatever deductions they thought were appropriate or whatever retainages they thought were not due. They, in fact, openly admitted that this is the amount that was due on the contract. There's no dispute as to that.
Can we sort of switch gears and discuss issue with respect to interest? The contract provides that interest will be determined in accordance with the PPB rules, correct?
It does not, Your Honor. There are PPB rules that govern extra work claims, which are not at issue in this particular case. There are numerous cases, we've cited them in our brief, in which interest at the statutory rate under the CPLR of 9% is paid by the city. In fact, I mean,
the cases you cite, I don't recall an appellate case. I think there were some trial level cases.
There may not have been an appellate case. However, the companion case that we're about to argue had a judgment in it to which 9% interest was added, and that amount was paid by the city.
But that's not saying once you get a judgment, you're not entitled to CPL. We're talking about prejudgment interest, right?
I believe that if you have to obtain a judgment, which we did, the prejudgment interest would also run at the same rate, at the 9% rate.
So
And there
then
are
what's
cases
the
that
point of
say
having that says if we don't pay you, we understand that it takes us some time to get through this stuff. So if we don't pay you within 60 days, you're entitled to 4.4% interest. What's the point of that if it's not to contract out of the state interest?
So that is specifically, Your Honor, under the PPB rules, in instances when the field engineer certifies on the payment requisition that the work has been accepted. This would be like an interim payment submitted to the
And
field
are
engineer.
you arguing that that happened here?
I'm not arguing. There is no. The city continues to argue that there is no approved requisition, even though you saw the back and forth in the colloquy with
it is
the
the very
court.
dispute that would preclude the granting of the interest under the contract. Because if there's a legitimate dispute as to compliance under the contract, you don't get the contractual prejudgment interest. That's pretty clear.
As I said, in the cases we've cited, and they're in our brief, interest is added at if there is a dispute, if these are disputed amounts, and these are contract balances, they're not extra work, which is what's governed by the PPB rules. They're not extra work claims. It's a contract balance. And in cases where that contract balance has to be secured by a litigation or a judgment, there is interest both pre-judgment and post-judgment at the
Thank you.
judgment rate.
Thank you very much.
Just very quickly.
Actually, I just want you to continue along this line with respect to interest. Now, what your colleague didn't suggest, but the trial court below, one of the bases it gave is that the city is in breach, and since it's in breach, we're not going to look at the PPB rules, but the CPLR controls. How do you respond to that?
I mean, I think that's incorrect. The CPL is very clear from the case law that that people can contract around the CPLR, and that's Article 43. The prompt payment provision is extremely clear.
But I'm just saying, I agree with you, but I'm saying in the event that you breach, if we find that you breach the contract at least with respect to substantial completion.
So if you have a disagreement, so the prompt payment provision, so as I say, assumes within it that there will be a disagreement. If the disagreement, I mean, the contract does not say we have a disagreement if the plaintiff is right.
Does it, or does it say basically like we understand that the comptroller takes a long time to write those checks? So, you know, if it takes more than 60 days to write the check, then you get interest.
And the PPB rules then provide if the delay is because of a dispute over the amount of money, then these rules, then you don't get interest.
And
And that doesn't then follow and say, if ultimately you find out that it's in the city's favor, that the city was right about the amount, you get 4.5%, but if you were wrong, you get 9%. That's a kind of a nonsensical contract and
Well,
not.
kind of, actually, isn't it kind of makes sense? Like, because that disincentivizes the city from saying that it doesn't have to pay because it doesn't agree with 18 cents of a $75 million contract. And therefore, when a court finally says, yes, you do, oh, well, I only have to pay 4.5%. So it kind of does make sense, doesn't it?
I think the purpose of the prompt payment, though, isn't about incentivizing these things. It's about recognizing that someone has money out of hand. They should get interest on it, and that interest, considering it's coming out of the public fist, should be at 4% or whatever the floating rate is. But just before we close, can I please address, as I want to make sure that there's a disagreement, a misunderstanding that's not in there. The city doesn't, there's a difference between being entitled to some kind of money and the city having breached. They sued the city saying that the city breached the contract. In 2020, when they submitted a draft piece of paper, like a draft asking to, like an opening salvo to start a process, the city did not breach contract. The city didn't breach the contract in 2021 when it issued their final extension of time.
Did you make a substantial completion payment?
No, because they didn't request it. At that point, they had to submit paperwork.
They didn't request it?
That's a whole heart of the whole appeal, and so we will address that issue, thank you, because that's what we have to ultimately decide, whether they did or did not validly request.
Thank you.
We'll definitely decide that.
And just thank you, Justice Singh. Good luck.
Okay, you could stay though, but just switch places now.
Oh, I think my colleague.
Oh, yeah, okay.
Oh, your colleague's going to come up, okay. You could switch places. Okay.
Okay, so this appeal is from a contract for the improvement of the Jamaica wastewater treatment plant in Queens, on which WDF was both the general contractor and the plumbing contractor.
So the way in which the lower court calculated it was wrong in terms of the soil excavation. In other words, you were not obligated to put in hours and materials. It was based on a unit price, correct?
Right, so with respect to the soils claim, every payment that was made was based on the cubic yards, the number of cubic yards of soil taken out of the ground. When the original allowance in the contract ran out, the city issued, through a change order, they increased the allowance by an additional amount and then would pay based on the unit price or the cubic yards of soil that were removed. And you can see in our papers from 2013 to 2019, the city was communicating with us, waiting for that approval of that last additional amount so that that change order 215 could be approved. Unfortunately, it never was, and now the city argued that you didn't have not records of the cubic yards of soil that were excavated, because we had that all along. They're saying you didn't have time and material records, like the number of men that were working on a day, the number of pieces of equipment, which just didn't really make a whole lot of sense. And the same thing happened with respect
The grout removal contract.
for the grout removal is a credit, so there's no way to keep time and material records of grout removal.
Particularly for work you didn't do.
Yes, particularly for work you didn't do.
How do you respond to your friend's argument on the other side that you waived your soil excavation claim because you continue to work under a unregistered change order?
Again, this is not the kind of work that is subject to, it's a unit price work under the contract. You simply do the quantities or number of units that are necessary, and it
Well, was there a course of
increased
dealings
each
here?
time.
Was there a course of dealings here?
There's definitely, there is a long course of
Right,
dealings.
so, and the contract says the city can try and negotiate a different price, but you're saying the city never did, and it was always contract price. That's what we did, that's what we got, that's what we continue to get. And so when some months later or years later, they asked us for a different metrics of time and workers and all that, we said, no, we're going under unit price, right?
And the city never asked for
As
different metrics ever.
never asked you to renegotiate.
Just on this appeal said you didn't submit time and material
And
records.
at
It's
the
kind of
time,
a
they didn't
knee-jerk.
seek to
defense.
renegotiate the price, did they?
No, they did not.
Even after it went up to, after 125%, you kept doing it, they kept paying you until,
Correct.
okay.
And
Correct,
what
Your
was the
Honor.
reason why you were continuing doing the work?
You had no choice other than had to do the work in order to get the job done, had to excavate soil in order to complete the facilities. And eventually what WDF did was they stockpiled the soil instead of disposing of it because they were not getting paid for that quantity of soil that had been excavated.
And there were 2 change orders that had been registered, and you were paid under those at unit price, correct?
Correct.
And at that time, was it over 125%?
I don't recall. I believe so.
in
I
any-
would say yes. No, I
Yes?
think it
And they
was.
never came to you and
They
said,
never
we want to
came.
negotiate a different price? And
Want to address the interest claim?
So the interest claim, Your Honor, there was a $40 million delay claim which was settled in
So
the
if it
year
was settled, how-
2023.
How could you be entitled to prejudgment interest? if it was
So what was settled was the delay claim. And the delay claim was reflected in the first and second causes of action. And we're not claiming any prejudgment interest on that settlement. That's done and over with. There was a third cause of action, which was a separate and distinct cause of action for a contract balance. It was excluded from the releases and from the settlement papers. Once the city settled the delay claim and discontinued its
Right, but
liquidated damages
Wasn't a
claim.
specific carve-out having to do with certain specified unpaid sums in the contract, which didn't include the contract price?
No, it did not, Your Honor. The settlement sum
What does
was
the release say? What's the language of the release that you're relying on?
saying that,
What's the language of the release? Since that's what we have to interpret, what the release did or
Correct,
did not
correct.
let go of, and the parties disagree about that. So what's the language in the release that supports the argument you're making?
the language of the release,
it's that the settlement is in full resolution of any causes and claims which its successors have signed, ever had, now have, or thereafter can have, or shall or may have, directly or indirectly, arising out of those 2 causes of action, inclusive of interest, costs, legal and attorney fees and disbursements.
and continues, Your Honor, except for any claims arising out of the third cause of action, which are excluded both in the language of the
And what's the
settlement.
third cause of action?
The third cause of action is the contract balance claim.
Meaning the claims we have now
Claims that went to
before us?
trial, yes, the claims that went to trial before us. And we recovered an additional $987,000 on those claims.
They didn't
But
appeal that.
The city made a payment on account of $5.2 million, which is money once they settled the delay claim and they had no counterclaim, they had no defense to not paying that money. So they paid the $5.2 million in end of 2020, 21. They paid that money, but it was basically just a credit, a payment on account, money that it was not in consideration of the settlement agreement. The
Let
settlement
me hear from
agreement
the other
was,
side, and you can continue this on.
sure.
Can you start out with the prejudgment interest issue? The prejudgment interest issue.
Sure, Your Honor. And let me begin my appearance, Your Honors. May it please the Court, I'm Alan Racines, representing the city, which here is the respondent. So on the prejudgment interest and the settlement stipulation issue, the settlement stipulation in this case
Also
on
move, I'm sorry, move the,
microphone, yes. The settlement stipulation in this case said that the sum was paid in full settlement of this action, except for the third cause of action relating to unpaid contract amounts, retainage, and extra work. And then it goes on to say at the bottom of that half of that page that the parties have agreed that the substantial completion amount would be paid. So that was not an unpaid contract amount. That was an amount that had already been agreed upon. There was no live claim on that. And as a result,
and you paid it. The city paid it.
I think it has been paid, Your Honor. I'm not sure that's in the record, but I don't think there's any dispute on that. There was there still needed to be a final extension of time approved, and then payment would be made within 45 days under the contract. And this is back in February 2022. So, and the release says basically the same thing. It carves out that portion of the third cause of action as to unpaid contract amounts and related matters, the retainage and extra work. So this settlement stipulation gets rid of, and by the way, the settlement amount for the amount agreed on for the substantial completion payment is down to the cent. It's $5.342 million on down to 23 cents. Is a very precise amount here, Your Honors, and now they're coming back and saying, oh, we also want interest. They're not entitled to interest. This has been this portion of the contract payment has been resolved.
So how do you respond to the argument that was resolving only the first and second causes of action, and in fact, the payment was sort of a payment on account?
Well, I think that I mean, first of all, I don't think it was payment on account because this in the sense that the paragraph 2 of the stipulation here says that the agreement will substitute for any delay analysis. So there was some stuff that had to be done, I think, if not for the settlement agreement, but the settlement agreement resolved that. But more to the point, I think the key, yes, it is true, I think, that the first two causes of actions do not pertain to the substantial completion payment. But the third cause of action is, again, the language is the settlement payment is made in full settlement of this action except for the third cause of action claims about unpaid contract amounts, unpaid. And this amount, there was an agreement already to pay.
And the numbers were actually listed, correct?
Yes, exactly. And
So we assume that if it doesn't say anything about plus interest or anything like that, right?
right, I mean, first of all, one would think that the numbers in paragraph 1 are different from the substantial completion payment in paragraph 2, and also, this is all in A1176, and also, as Your Honor says, when it's down to the cent, you would think that, you know, you've figured out the amount that's due and no interest would come in after the
And
fact.
any and all claims generally means any and all claims, right?
Well, yes, that's certainly true too, Your Honor. I agree. Yes, of course, I agree.
To address the soil excavation claim, as
Sure, Your
to
Honor.
why the city believes, and which the court below accepted, was that it's on a time and material basis and not a unit price, which the contract seems to say that it's a unit price. And that's what, as your adversary has brought out, what they were working under for a long time.
Yeah, so I mean, I think my colleague and I agree that we're beyond the 125% of the total amount contemplated by the contract.
Did you ever ask them for any other price? It says you may, doesn't have to. It says you may try and renegotiate. Did you ever do that?
Well, we did negotiate a contract price under the change order that was never ultimately approved and registered. There was a negotiated contract price, Your Honor, but it was not, that's in the change order, but the change order was never approved and registered, and that was the issue. In fact, what
So
ended
in
up...
other words, you wanted them to continue doing the construction. Your construction manager has been telling them, proceed with the construction. They have to excavate to do the work. So in effect, you'd be putting them in breach, right? If they'd stopped the soil excavation?
I don't think it would be a breach, Your Honor, because the extra work becomes part of the contract only when it's approved and registered. Until then, it's not part of the contract, which is why you can't make payment, the city can't make payment on it either. So if they, you know, and as Your Honors know, the PPB rules are incorporated, I think, for these purposes.
Are you saying that they did the work on their own without being directed to do it by the city?
Well,
I think your witness testified he directed them to do it, correct? And now you're saying even though the city golly, testified at trial, I directed them to do it. And now you're saying he directed them to do it, but we're not paying them for it. Is that your position?
Well, I think that the position is that there's a process that has to occur. And on page 2109 of the appendix, there is the PPB rule that we believe, I'm not sure if my colleague disagrees with this, but I think it's pretty clear from the contract that rule, along with other PPB rules, are incorporated into the contract. It makes clear that a contractor who does work beyond the scope of the original contract without an extra work order or change order having been approved and registered, they assume the risk of that work. And so those are the terms of the contract, Your Honors. And I don't know if there was no allegation of bad faith here that could, I'm not even sure if that would be an equitable exception, but certainly I don't see that being made in the first place.
So there were two change orders that did go, and you just did the unit price, right? Prior to this one that's now in dispute, there were 2 change orders, and you had them at the unit price.
You mean the same one
You
as in the
didn't-
contract?
Right, and you
Your Honor?
didn't try and negotiate anything else. You said, we'll pay them at the unit price, which was like, I forget.
I think it was $80 a square foot.
Yeah, but
So
I'm
you
not
had been doing that and telling them to keep going, and now now you don't want to pay for the extra work that they did.
Well, Your Honor, the
Is
thing to
that
keep
it?
in mind is that there was a change order that was subsequently approved here. and-
Two change orders.
Right, but after the one that was not approved and registered, there was one that was entered for similar work but less work. I don't remember the unit price for that, but it was less work. In other words, it was fewer units being,
I don't know why that would make any difference.
Thank you.
in the sense that, Your Honor,
Thank
that
you.
there's a
Okay.
difference in terms of what they're asking for in terms of the total scope of work. Thank you, Your Honors.
Yeah, if I may, and I apologize for not having it at the ready when you asked originally, Your Honor. But in terms of, so that the contract balance claim was actually $9.8 million. After the delay claim was settled, there was a $9.8 million claim. The city paid that $5 million that we talked about on account. The rest of the claim still went forward, and that's what went to trial. What was the balance on the rest of the work? But if I go back to that settlement agreement, the settlement agreement says WDF agrees to accept the settlement sum, which was the $24 million. You see, it's a defined term, in full settlement of this action, except only the WDF does not waive its right to seek payments for its claims currently advanced in the third cause of action in the third amended complaint for allegedly completed but unpaid base contract work, retainage, percentage, and claimed extra work under 2G and 2B contracts. And then, this is all at page 3 of our reply brief. And then in the release specifically states, the release provides that WDF, as release of valuable consideration in the amount of $24 million received from the city as releasee, receipt of which is hereby acknowledged, releases and discharges the City of New York and the New York City Department of Environmental Protection from all actions except only that releaser does not release their claim for one,
You
payment.
know what, we can read this.
We can, okay,
We
so
have
I
it.
just,
Right, but there are 2 numbers, 2 specific numbers in there. We don't release $9,681,000, and we don't release $376,814. It doesn't say plus interest, it doesn't say prejudgment interest, and the release says any and all claims except for 9,681,525 and 376,814 are released.
which the interest would go with those
Why
claims.
would that go
Why
if you
wouldn't it go with
release
those claims?
any and all claims except for that number, those 2 numbers? Why shouldn't we just read it as the way it's written?
Because the interest would naturally go with those claims. Interest is not something that has to even be requested,
Thank you.
right, under the
Thank you.
cases. Thank you, Your Honor, for your,
People versus Vasquez.
Thank you, Your Honor. May it please the court, Jesse Weiss from Cruz, Swain & Moore, with the Office of Appellate Defender. I represent Mr. Vasquez as pro bono counsel. Your Honor, I'd like to focus my time today on 2 issues. Mr. Vasquez's counsel's failure to move to strike the testimony of prosecution witness Freddie Ramos, and if time permits, the fairness of Mr. Vasquez's sentencing. That failure was ineffective assistance for 2 key reasons, Your Honors. First, Ramos was the linchpin of the prosecution's case. And second, on cross, Freddie Ramos pleaded the Fifth Amendment 8 times on matters that were neither collateral, cumulative of other trial evidence, nor collateral to his direct testimony. Now, on both of these issues, it's critical to understand the context of the cross-examination in question. Mr. Ramos is Mr. Vasquez's older brother-in-law who admitted to shooting at the victims here and facing a lengthy sentence, entered a plea deal where he testified that Mr. Vasquez participated in the shooting, had a motive, and supplied the guns. Now, there's no dispute that Mr. Vasquez was with Freddie Ramos at the time of the shooting, but the defense theory was that Mr. Vasquez did not know that what Freddie Ramos planned to do. Freddie Ramos started shooting for his own reasons that had nothing to do with Mr. Vasquez. So it was incumbent on counsel to show that Mr. Ramos had a motive and may have acted alone. Now, counsel had information that indicated that this precise area of the shooting was Freddie Ramos's drug turf that he had protected in the recent past with gun violence. Those matters directly related to Freddie Ramos's direct testimony. It supplied a potential alternative motive for the shooting. It might have shown that he committed the shooting to protect his drug turf, as he had done in the recent past.
Was there any testimony elicited at trial that the victims were rival drug dealers and this had something to do with the drug dispute? Was anything presented at trial that supported that claim?
No, Your Honor, because when these questions were asked 8 different times, Freddie Ramos pleaded the Fifth Amendment, and that's the essential problem here.
Right, but wasn't, in the absence of any testimony, isn't it speculative that anything would be elicited from those questions as opposed to it being collateral? Well, there's nothing, no other testimony, nothing else in the record that was supporting that theory.
Your Honor, the standard
You
here.
can't question about everything. At a certain point, some things become collateral. And without any other evidence, why wasn't that collateral?
Sorry, Your Honor, and it's not collateral because the information that counsel had related to the specific area of the shooting in question. So there was a nexus between the information that he had and that he tried to ask about. Was this specific area where the shooting in question happened your drug turf? Did you protect it from encroachment in the past with gun violence?
There was no evidence that this was the motive, that there was a matter of rival drug gangs trying to protect drug turf.
Correct, Your Honor, but the standard is whether the questions that were asked but not answered might have elicited information, testimony that would undercut his direct testimony. So there's no requirement of definitive proof for evidence that this was a drug dispute.
It doesn't have to be beyond speculation. I mean, why isn't this just speculative questioning without any evidentiary foundation whatsoever to support this or any information to support this?
Well, Your Honor, the record's clear that there was a foundation to ask these questions. Counsel had a foundation. He had sufficient information, a reasonable foundation.
You keep saying he had information. What is that information? How do we know that? Where is that in the record?
He said it in the record that he had information that Freddie Ramos dealt drugs in this area, that Freddie Ramos committed.
Mazzone testified at a hearing, at a 440 hearing, didn't he?
He did, Your Honor.
Didn't he testify that his purpose in asking these questions was, as the purpose was to affect general credibility?
His testimony is not crystal clear, and this is 10 years after trial, so I think
you
it's
mean he
clear
didn't testify that his purpose was to evoke material on general credibility?
His testimony is murky, Your Honor, but I think two important points on that, because the 440 court did find that his...
If it was for general credibility, would it be error to conclude that that was collateral and would not get you to a reversal?
It would be, Your Honor, because counsel's purpose in asking the questions ultimately is not the relevant question. But for 2 reasons. One, in United States v. Cordelia, the Second Circuit case that is a seminal case in this area, the defendant's counsel in that case moved to strike and said, the reason I'm moving to strike is because this relates to general credibility, and I was unable to test that. The court looked at the actual questions themselves and said, does this actually just relate to general credibility, or is there some nexus, potential nexus, to the crime that the witness testified to? So you got to look at the character and the nature of the questions themselves. And 2, Your Honors, if it's true that counsel failed to comprehend the import of the information that he had. I mean, his one job here was to
Was he asked at the 440 with respect to the whether he had a good faith basis or what the basis of the information he had that this was drug turf?
He was, Your Honor, not exactly in those terms, but he was asked, did you have a foundation or a basis for these questions? And he answered, I did. He said, I couldn't recall, he couldn't recall at the hearing the specific basis, but he said that he did. And at trial, he asked the questions. The prosecution didn't object. The judge allowed them.
I'm sorry to interrupt, but you only have a short time left. Do you want to address the sentencing issue?
I would like to, Your Honor. So,
and how old was your client at the time of sentencing? There seems
19 years old.
In the record.
Yeah, it's 19 years old, Your Honor. There seems to be a typo in the pre-sentencing report, but if you look at the last page of the report, it shows that he was born on February 12, April 12, 1986.
And, okay, and I don't think the prosecution agrees with that.
Well, on the first page of the sentencing report, it says 1984. If you look at the last page, it says 1986. In the trial transcript, it's 1986. There's other, in the sentencing and commitment statement, that it says 1986. His birthday's 1986. It looks like it's a typo on the first page of the pre-sentence.
Okay.
So he was 19 years old, and as this court recognizes, he was an adolescent. This court does take that into account in assessing whether a sentence was fair. And the other thing I'd like to point to on the sentencing, Your Honors, is just the overwhelming volume of support that he received from just all corners of life, from a charitable foundation, assistant director of the Cerebral Palsy Foundation, his wife, his employer, he had a union job at the time, and his church, and showing also that, you know, during his time in prison, he was in rehabilitation programs. Just an overwhelming, you know, record that this is someone who is on the road to rehabilitation and has strong prospects.
Yeah, let me just ask you, does he have a good disciplinary record in prison?
Your Honor, that's not on the trial record, but our understanding is, yes, he does. He's completed.
What in the record shows that?
No, it's not in the record, he said. I was just curious as to.
Thank you.
No disciplinary, sir. Thank you.
Thank you very much.
May it please the court, Charles Wan for the respondent. Your Honor, the 440 court credited trial counsel's testimony at the hearing that the purpose behind his questioning was just to basically impeach Ramos's general credibility. And so the court basically decided that counsel was not ineffective for not having moved to strict Ramos's testimony because the motion would have failed. And as I believe Your Honors have a firm understanding of the relevant facts and the law in this case, unless Your Honors have any questions.
Yeah, can you address the sentencing issue?
Your Honor.
He's 19 years old and he got 22 and a half years, which is actually longer than his life at that point. What's the justification for that?
Your Honor, he was basically responsible for having killed one individual, and a second individual was hospitalized for several weeks, I believe, and without medical treatment, he basically would have bled to death. And I believe this sentencing court pointed out that defendant basically had a pending felony charge, although it was for, I believe, selling drugs, but he already was been arrested and he was been released on this felony charge when he committed this crime.
And he was out on bail on this case. He was out on bail on this case when he committed the drug felony.
No, I believe he was out on the drug felony when he committed this crime. I think that's what sentencing court said. I might be mistaken, but he was, I believe it was...
was the drug felony 2006?
I could be mistaken on which one occurred
Maybe
first,
it was
but
parole.
sentencing court did point out that he was out at the time basically, he was under arrest when he committed a second crime. Basically, that he shows he doesn't have any kind of remorse for the crimes he's committed. And the sentencing court basically felt the heinous nature of this crime.
Much is made of the fact that Ramos's record is worse than the defendant's record, but did they both basically have a similar record in which each one, in terms of each one had one other felony?
Well, Ramos received a lower sentence because
he made a deal.
Yes, Your Honor. And this, I mean, of course, I've always said that plea agreements, they do result in a lower sentence than one might have gotten of the sentence, but that doesn't necessarily mean that that the co-defendants who went to trial did necessarily got a more drastic or higher sentence than the one who pled guilty. Because, of course, I've always pointed out that we want plea agreements. They basically reduce, what is it? What's the word I'm looking for? They want to support it because it leads to certainty in the justice being served and judicial economy, and that's why it's understood that plea agreements...
The defendant argues that that the defendant was under the influence of Ramos, that Ramos was older and that he had control, so to speak, of the defendant. Is there anything in the record which supports that?
They were supposed to have grown up together. They knew each other from very young, but it is unclear that he actually had undue influence over the defendant. All we know is that Ramos is married to defendant's sister, and so they've known each other for a long time, but there really is no concrete evidence in the record that Ramos had any kind of undue influence over the defendant. And the testimony here was that it was defendant who basically said to Ramos, "I seen these individuals, let's go shoot them up," what they had done.
The gun was in the defendant's home, right? There's no dispute that it was Vasquez's gun. Is that right?
Well, there was Ramos's testimony that Vasquez retrieved it from his house.
Right.
Defendant disputes it. I can't say it was undisputed because we did not retrieve the guns from his house.
Did they put in evidence putting in issue that the guns came from Vasquez's house or home?
We just had Ramos's testimony that Vasquez retrieved it from his
Ramos
house.
says that Vasquez went to get the guns and brought the guns to the scene, right?
Yes, Your Honor.
And did anyone
Is
dispute
there
that?
evidence? Is there evidence that Ramos got the guns?
There was no such evidence, Your Honor. No one testified there was Ramos who got the guns. The defense presented evidence that his family did not, in the past 24 hours within of the incident, they did not see any guns in Vasquez's house, but there was no
Which becomes
testimony.
another issue in the appeal in which the defense wanted to elicit that it's over a longer period of time, and that became the subject of a limiting order because the people were then going to elicit testimony of the defendant being involved in another shooting. Is that correct?
Yes, Your Honor. The court decided that, Ramos' testimony basically just that he retrieved the gun from his house at that
The
time.
defense wanted to present evidence that the defendant had nothing to do with the guns. So the people came back and said at that point, well, if you elicit that testimony if you present such testimony, we're going to cross-examine about the fact that Ramos said that the defendant shot a cab driver or threatened a cab driver with the gun previously. Is that correct?
I forget the underlying details of what Ramos' testimony was going to be, but what basically was going to be that he had seen Vasquez with a gun in a prior incident.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. Just briefly, on the speculation question, again, Mr. Mazzone testified at the 440 hearing that he had a basis to ask the questions that he asked. He asked them. Freddie Ramos invoked the Fifth Amendment 5 times, and counsel moved on. He did nothing else with that information. And I think some of these questions are getting at the overall fairness of this trial. He was, counsel was unable to put forward the defense witnesses that he wanted. The entire prosecution case came down to Freddie Ramos testifying that the guns came from Mr. Vasquez's house and that Mr. Vasquez was the mastermind here.
Well, no, not really. He put on testimony to dispute that, right? He put his mother and somebody else has said that they didn't see, a brother, I think, that they didn't see any guns in the house. So it wasn't, he was able to meet those allegations.
He was able to put on some testimony that was very, very, very constrained and limited by the court's ruling. But I do want to.
But when you say that the case came down to Ramos, there's no question that Ramos is the key witness. But Russell also testified, didn't he?
He did, Your Honor.
And he testified to there being two people, him seeing two people, right?
That's right, Your Honor. There was no dispute that Mr. Vasquez was with Freddie Ramos, his older brother-in-law by a decade.
There's also no dispute that there's ballistics evidence which points in the direction of two different weapons being used. Is that also correct?
That evidence is as a number of witnesses
that to discredit that evidence because the bullet was on the other side of the street, but the fact is the ballistics show that there were two guns involved.
Yes, sir. But
Thank you.
Thank you, Your Honor.
Rent stabilization versus McKee.
May it please the court, Anthony Docty for the appellant, plaintiff appellant in this case. I'd like to focus your attention on the issue of public person versus a limited purpose figure.
So why isn't the RSA a limited purpose public figure?
Yes, Your Honor, and it's not a limited public person or figure because it never participated in the committee's meeting. The committee meeting that I'm
But that's you're making it very narrow by that description. It's not just whether their participation, it's whether generally in the world they are limited purpose public figures in the field of rent regulation and landlord-tenant legislation, not their specific role in that that circumstance. So why with that broader definition, why wouldn't they be a classic fit of a limited purpose public figure?
Yeah, sure, Your Honor. I think the United States Supreme Court laid it out pretty and specifically. You have to take a look at the issue at hand, and the issue here was the committee meeting. The committee meeting was a city council meeting, and it was open to the public.
What was the purpose of that committee meeting? Wasn't it to talk about vacancy decontrol?
It was to talk about whether or not they were going to take they were going to take public comment, Your Honor. For the
And does the RSA talk about vacancy decontrol?
not at this hearing.
Not at the hearing. In general, does it speak about vacancy decontrol?
I wouldn't know,
Does
Your
it
Honor.
send out newsletters? Does it go to the newspaper? Does it have a Twitter account? All of that talking about what was being spoken about the hearing.
I think, Your Honor, that the record is empty on that issue. However,
I think your client testified to that. I don't think the record is empty at all. Are you denying any of that? So let's be clear. Are you denying that this organization discusses the issues about rent regulation regularly in the public forums, including Twitter and in newsletters and in every other possible public forum? Are you disputing that?
And to add to that, they've been doing it for the last 40 years, correct?
yes, Your Honor, it is an advocacy group. It's a trade association, and the trade association assists the landlords in New York City with respect to legislation, with respect to the rules, with respect to everything that landlords are concerned with.
No, you don't just assist the legislatures, you speak to the public. You issue newsletters, you put out Twitter feeds, you do all those things, correct?
Yeah, absolutely correct.
And you're also lobbying for legislation.
We are, Your Honor.
And you're saying that you're not a limited purpose public figure in the context of discussion of that issue at this hearing?
That's right, Your Honor, because we didn't appear at the committee hearing, and we are taking
Let's
a
assume we
narrow...
don't agree with that. Let's assume that you don't have to be at the meeting.
Is that position consistent with the recent Court of Appeals case, which
Gotwell.
my colleague was on?
It's an issue, there's no question about it.
Clearly not.
It
is clearly not consistent with Gotwell.
Yes, yeah, and you're right on that, Your Honor.
So let's assume that we don't agree with you on that issue. What else do you have?
Well, Your Honor, let's assume for the moment we disagree with that, but now we're talking about a heightened standard of defamation.
Well, there's nothing here to suggest on this record that Mr. McKee gave that testimony concerning the alleged lobbying the payment to certain Democratic senators for their election campaign as being made with actual malice here, intentionally known falsehood. Well, because the record is clear that this information comes from public campaign records.
Well, I would disagree with that wholeheartedly because the deposition was very clear. We had asked him, now keep in mind that RSA was not on the agenda on the committee meeting.
Yeah, but he didn't mention RSA. He basically, in the context, he was discussing that he was concerned that the city council would not do something that he believed would be pro-tenant, and he was there representing a tenant PAC. He certainly didn't identify himself as being a member of the Met Council at that committee.
I would totally disagree. And if you look at the transcript of the city council meeting, that's exactly how he was introduced.
Let's get more granular. Let's look at the statement,
Yes.
which is in 2010, when the Democrats had one vote majority in the state Senate, the real estate industry, the RSA, went to 3 Democratic senators and promised them $150,000 in campaign funds. So it says the real estate industry, the RSA. It says both. And then when you go to look at his deposition testimony where he talks more extensively, he definitely talks about bundling. He doesn't say that all the money came from one group, which is what would make it illegal. So why didn't that deposition, to the extent there's any ambiguity in the statement, why didn't that deposition testimony clarify what his intent was with respect to?
Two reasons, Your Honor. We didn't sue him on bundling. He never made a bundling comment at the committee meeting. As a matter of
He said
fact,
the real estate industry, comma, the RSA. He didn't say the RSA made $150,000. It's not in dispute that the RSA did make contributions. It's just whether they made $150,000 contribution.
I think you have to look at 2 comments that he made, one in the committee and then 2 months later to the Real Deal, where not only did he say, and he didn't stop short and with the acronym
They bought
RSA.
off they, he doesn't say RSA.
He does.
So again, they is a very different statement than RSA did it.
He specifically said the real estate industry, RSA, and to be perfectly clear, he said the Rent Stabilization Association. He named them.
Okay,
That
I'm going to
doesn't
let you
dilute.
further elucidate that on rebuttal.
I'm sorry?
I'm going to let you further elucidate that on rebuttal.
Yes.
Your time. I'm
time's-
going to let you
Thank you.
come back on rebuttal.
Good afternoon, Your Honors. Turner Smith representing Mr. McKee and Tenants PAC. Let's just seal off, I think there's general agreement on the panel that the question of whether RSA is a public purpose and limited public purpose entity is pretty well determined. But just to bring us back to the
Just to clarify, anything we say in oral argument is not necessarily our position. We're asking questions. So you
Fair
can't
enough.
assume that we've decided anything yet because we haven't decided the case.
Fair enough.
But go ahead.
So, there's an easier shortcut. There's a very, very clear path now under the amendments to the SLAP law, which now apply. There was a sort of an interregnum between the time we've started our summary judgment papers until Gottwald went up to the Court of Appeals and was eventually determined that we also had rights under the Civil Rights Law 76A. And that one gives you a straight beeline right into the very high standard that RSA has to meet in order to prevail on their claim of defamation. The 76A requires that it shifts the burden as long as this is a matter of public participation, which clearly this was, on a matter of public interest, which very clearly this was, the hotly contested issues surrounding rent stabilization. 76A takes you right to the point that the burden shifts then to
No, but you didn't argue this in front of the trial court, did you?
we didn't speak.
So let's talk about what you argued, and we can't do that now. Talk about what, the question is there evidence of actual malice, right?
Okay, fair enough. The issue at the heart of this is this an actual malice situation? And I'd like to just take you into the committee room and think about what.
But let me ask you this: Did he, when Mr. McKee was deposed, did he say he did look at some information? He wasn't speaking off the top of his head, right? He did do research. He looked at public documents. In fact, one of the people that he named actually did get $150,000 or maxed out on his donation. Correct? I mean, I think the
That is absolutely
RSA's
correct.
witness. So the question is, in that regard, what has the RSA showing that he did do research, that some of what he said was confirmed, even by the RSA? What else could there be to show actual malice? Was there anything in your view that could have showed that he acted with knowledge of falsity or reckless disregard?
What happened here is that they took the deposition of Mr. McKee, and each time he said, "Well, look, I had looked at the contribution ledgers. I was talking to other people," and he actually names names of different people that he spoke to. And his takeaway back in 2010, 8 years prior, as he recalled it, was there is evidence of a bundling, at the very least, of money that was being provided to these Democratic senators.
Well, bundling meaning the real estate industry was contributing money, correct? To
Not only the real estate industry,
and
yes,
RSA, as the president testified.
and the RSA,
But that's not what you said. It's not what you said at the committee hearing. I mean, what you said, the Rent Stabilization Association went to 3 Democratic senators and promised them $150,000 in campaign funds if they were to vote against 2 of our bills, and they did indeed, skipping along, and they did indeed follow through on that pledge to give them $150,000 each. What are you saying there?
what he is saying
There's
is,
nothing about bundling in that statement.
but what he is saying is the industry itself made the promise that this is classic lobbying.
But you said the
technique.
Rent Stabilization Association.
It
so you
does
said
say the
that a
rent
specific-
stabilization.
Basically, you said that a specific
He
entity.
didn't say anything. Go ahead, I'm sorry. He didn't say it.
I understand. He understands that. Basically, your client said that the RSA paid off 3 senators with $150,000 in contributions.
That is not the way I read that. And let me just explain how.
So how do you read that? I mean, isn't that its plain meaning?
I read it in the way, first of all, under the circumstances of what was going on in that committee room, number one, and number two, on his own testimony at the deposition, that he was thinking always in terms of the real estate industry. You can see it in the prior pages of the transcript of the committee hearing, where he says, don't make a mistake here, the real estate industry gets what it wants to get, and it gets it by donations. And then he goes in, but remember, this is a spontaneous, unplanned, off-the-cuff comment. He didn't come to the committee hearing gunning for RSA. He came to the committee hearing, he delivered his remarks, his written remarks, no mention of RSA, and it's only when Council Member Richie Torres asks him a question, a totally unexpected question, namely, well, what do you think the chances are of passing real rent reform or vacating or gutting real rent reform? I don't know which one. And so he spontaneously, Mr. McKee, spontaneously launches into something, and you can almost see he's starting one way and he's going the other, and the
Yeah, but that's not the test. The test is whether he lied, and if he did lie, did he do it with malice? We don't care whether he spoke off the cuff or not. We
Thank
care.
you. No, thank you. She didn't actually ask a question. Thank you very much.
Good afternoon, Your Honors. My name is Scott Kim from the law firm of Patterson, Belknap, Webb & Tyler. I'm here today as pro bono counsel to on behalf of Met Counsel, the respondent appellant. Met Counsel joins in the arguments of our co-defendants, but I'm here today
But they never authorized Mr. McKee to go to this committee and speak on their behalf, correct?
Exactly, Your Honor, as you said.
Whereas they did have situations where their in-house person would help shape testimony on their behalf, but not
Exactly,
with
Your
Mr. McKee.
Exactly, Your Honor. That is the basis of our argument. That
If we were to agree with Supreme Court, isn't your appeal mooted out?
So, Your Honor, given RSA's appeal, we cross-appealed to address this issue that we felt Supreme Court erred in the event that we are overturned on the points that we prevailed on. In the event that you still agree.
You only did this in case Mr. McGee didn't prevail. If that appeal didn't prevail, so you wanted to have the second point that, well, look, Mr. McGee didn't testify on our behalf. But if the other portion of the appeal prevails, you really have no interest in what happens on this.
Save for one exception, Your Honor. We still don't know if they would intend to apply it to the Court of Appeals, in which case we would still want this part of the record to be up for appeal in the event that you decided.
Yeah, but generally we don't decide issues that we don't need to decide. If we affirm the dismissal on Mr. McKee, then you're automatically out of the case, right? Because you only are in by vicarious liability, for lack of a better word, right?
If I'm understanding, Your Honor, correctly, if we prevail on our co-defendants' arguments in their briefing that we've joined.
Right, and the only way you would not prevail is if McKee didn't prevail. Oh, I'm sorry, let me say that the other way. If McKee prevails on appeal, then a fortiori you prevail.
Yes, Your Honor. The risk would still be that the Court of Appeals takes up the case and overturns.
That's why you needed to bring the appeal.
Right.
But you don't need a decision on the appeal. You needed to bring the appeal to protect your position.
Yes, Your Honor.
But you don't need us to decide this.
It depends on the way Your Honors come down on. I think we're a bit
yes, we're all on the
circular
same
here.
page.
Yes, but yes, if we prevail on Mr. McKee's appeal, then yes, we do not need to pursue this further. We only
ultimately,
cross-appealed because they appealed.
If the Court of Appeals sees it differently, they'll remand it back to us for appropriate proceedings, correct?
Yes, Your Honor. To get into the substance, though, just with the time I have remaining, we would just point, Your Honors, to four indisputable facts in the record that Your Honors have alluded to, and the first being that Mr. McKee's spoken and written testimony only includes representations on behalf of Tenants PAC. He only mentioned by way of background at the very beginning his credentials, which includes Met Counsel, that he is a board member, but he then makes very clear in his testimony on at least 2 occasions when he is speaking on behalf of Tenants PAC. He says Tenants PAC urges you, and other things of that regard. Tenants PAC supports, and these are the quotes in his written testimony, as well as what he said on the record at the actual hearing itself. He's never made any such representations on behalf of Met Counsel. Met Counsel was only mentioned once throughout the entirety of his testimony, and again, that was at the very beginning when he simply mentioned them as way of his credentials and background. Second, Met Counsel asked 12 different people to appear on its behalf at this hearing, one of whom, Ms. Kathy Wakeham, actually did attend on Met Counsel's behalf. Of those 12 people asked in that email, Mr. McKee is not included. Third, both Mr. McKee and Met Counsel's representative in this case, Ms. Shapiro, both testified that he did not appear on their behalf, that nobody from Met Counsel asked Mr. McKee to appear on his behalf, and also that board members like Mr. McKee had never testified before a committee hearing such as this one in the entirety of Met Counsel's, or to their knowledge at a minimum. And then fourth, again, just Ms. Kathy Wakeham was the only one who sent her testimony in advance to anybody at Met Counsel, Ms. Shapiro, and Ms. Shapiro provided comments on that testimony and said, you're good to go. There is no evidence in the record whatsoever that Mr. McKee ever sent his testimony in advance to Met Counsel or that anybody helped prepare Mr. McKee for his remarks. If Your Honors have no other questions, I'll defer the rest of my time.
Thank you. I think 2 things are important to really grasp here. When the statement was made, it was made at the committee hearing. The second statement was made to The Real Deal, a magazine. But this court has to be careful what happens after the statement is made. Now, everyone's backing away. Oh, we didn't do this, we didn't do that. I didn't say this, I didn't say that. If you look at the city council transcript on appearances, there's the record. That's who was there. He said, I'm here, met, tenant, he says it, and that's the official transcript. Now we're going back and we're saying, oh, that's not what we meant. Met Counsel was sitting right next to him at the committee meeting and didn't correct the record. He is not here to talk on our behalf. Didn't do that.
Well, going back
Subsequent.
Counsel, going back to the issue of actual malice, you would agree, wouldn't you, that the statement, if it had just said the RSA was paying $150,000, would be a lot stronger. But McKee, with a much broader brush, referenced the real estate industry, correct?
I think, Your Honor, he says this it's in the record, the real estate industry, RSA, the Rent Stabilization Association, paid 3 senators. I just edited that, right? We promise you follow
No, it
through.
says promise them in campaign funds. It didn't say he was going to pay them each $150,000.
Gomera says
Hold on, let me
sorry.
finish. My understanding of his deposition testimony is that it was based on public campaign records is he made those statements. How have you at this point raised an issue of fact as to actual malice?
Clear, in our view, Your Honor, we did a very good job on that because we asked him in our deposition, what information did you have at the time you made 2 statements? It's not just one, it's the real estate deal. He went to, 2 months later, he's in front of the press. Am I up?
Just wrap up the answer.
He's in front of the press saying, bring it on. I've got the proof to show that these guys were paid off. And there is no proof, Your Honor. Thank you for it.
Thank you very much. Cruz versus PMG Construction.
Teresa Din for the appellant. Good afternoon, Your Honors, and may it please the court. The lower court here erred in finding an issue of fact on plaintiff's labor law 240 claim because this is not a 240 case. This is not the kind of case where a window was negligently left behind, waiting for the next unsuspecting victim. Everyone on site, including the plaintiff himself, a window installer, the construction manager on site, they all said, this is how these windows are stored. This is an accepted industry practice for safely and securely storing windows, 4 to 5 of them leaning against the wall. The lower court reached the wrong conclusion for 2 main reasons, right? So there's no evidence in the record that this window generated sufficient force as it fell. The lower court didn't even go through that analysis. They skipped right to, they should have provided, there's an issue of fact regarding whether.
Why isn't there an issue of fact as to whether there was sufficient force?
Because the body of case law is clear. Violations of 240 are found where falling objects are situated at the same level as the worker, only where the object is extremely heavy, 1,800
Okay, so how much,
pounds.
I'm sorry to interrupt, how much was the weight of the window here?
Well, the plaintiff said that he didn't know and that he could not approximate the size.
Okay, my understanding, just to cut to the short, that in the record, it's anywhere between 225 to 250 pounds. Is that an incorrect statement?
The plaintiff's speculation. He also admitted in his testimony that he did not know the size, the weight, the height of the window. He later speculated maybe it was 225 to 250 pounds. He did speculate at some point after already admitting that he didn't know the size, the weight, the height of that window.
Did you introduce any testimony, after all, it's your motion for some reason, that in fact the weight was de minimis or?
We did not, Your Honor.
I mean, and you look at the picture of the window, it doesn't look like a 3-pound window. It doesn't look like it's speculative to say that this was a 200-pound window. There was a lot of evidence showing what the windows look like. They weren't little tiny wisps. So to say there's no evidence in the record is not quite right, right? These don't look like 5-pound windows, do they?
No, Your Honor.
Yeah.
And you also have opposing experts here as to whether these windows needed securing, don't you? Didn't Herman Silverberg for the plaintiff say that these windows should have been secured?
The plaintiff's expert, Your Honor, though, he wasn't on site. Everybody on site said it was safely stored leaning against the window, that was fine.
The expert is never on site. I mean, he's obviously called into the case at a later time.
Yes, Your Honor, but our expert refuted the plaintiff's expert.
That gets you to the issue of fact.
Incidentally, was your expert on site?
No. However, his testimony was uncontradicted that, look, these windows are resting at equilibrium, right? They're in excess of 90 degrees. In order for the window to fall the way the plaintiff says, unsecured, it would have had to slide out from the bottom. That didn't happen here. The window tipped over forward.
That sounds like a really good argument for trial. Why should that be accepted here?
Because it was that expert opinion is uncontradicted by plaintiff's expert. He never said that math is wrong.
Can you address the 241.6 claim?
Excuse me?
The 241.6 claim?
The industrial regulation, is that applicable here? Were the windows obstructing a passageway of any kind here?
The testimony, our position is that the testimony is that the testimony is clear. The accident happened in an open area, in the middle of the first floor. It wasn't in a hallway. It wasn't even at the top of the ramp. It was 10 feet away from any kind of, 10 feet away from the ramp, in the middle of a room.
With respect to Labor Law 200, did your client control the means and methods, or was it solely the employer or the employee?
It was solely the employer-employee. The defendants testified was construction manager. He said, we're the construction manager. We look over overall general safety at the project, but we're not window installers. We're not window experts. We don't tell these window subcontractors on how to do their job, That was their expertise, the subcontractor's decision.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Lisa Como for the plaintiff respondent. With respect to the 240 issue, counsel's argument that, oh, well, it was accepted custom and practice to store the windows in that fashion, certainly point out that Labor Law 240 is a self-executing statute. It doesn't have reference to those kinds of industry standards. And in any event, there is a clear, I think the facts actually are clear, that there's no foundation for their experts' assumptions concerning the manner in which the window was resting.
Well, didn't your guy pull a suction cup off the window like literally 2 seconds before it fell?
They argue that
sure, I think there is some kind of factual basis for the expert's statement that there would be nothing that could have, what caused that was your guy pulling the suction cup off.
And that's their sole proximate cause argument. But even before you get to that, Your Honor, the expert has diagrams and he makes assumptions that the window is resting in a way that's directly contradicted by the testimony. The expert assumes, and defendants assume, and they keep arguing, that the window is leaning back against the wall. But the plaintiff testified that it was resting on its edge and that it's far more vertically up and down than the 45-degree angle that they're asserting. If it was at a 45-degree angle, yeah, this probably never would have happened if it had been secured in a position like that, but it wasn't secured, and it was resting on its narrow vertical edge. And I would like to, it's certainly in our brief.
Are there any pictures establishing that? It's your client's testimony, right?
The only photo that we have...
it's essentially based on your client's testimony.
Well, he identified the photo at 9:46 and 9:47 as looking like the windows, but it's not the same. They were not on pallets.
Right, but obviously those are the ones that he says look like they did aren't vertical, they're horizontal, right?
Right, because they're resting on wooden pallets. They're in a different location. He was just saying those are the kinds of windows we had at the site.
It's not clear to me that that's what he was saying. It's not clear that he was not saying that that's how they looked, except they weren't on pallets.
Well, he also said that they were on an uneven ground. And I would also, getting back to the suction cup for a minute, and of course the defendants also argue that, foreseeability is not a requirement in Labor Law 240, but there is a foreseeability basically in the first instance about whether or not you need a safety device.
I don't understand why we're going down this road. I mean, there was a finding of an issue of fact.
Yeah, I submit that there are questions of fact, but they're arguing that as a matter of law, removing a suction cup from a window as part of your normal and expected job duties is going to cause this to fall on the worker, and it's okay not to secure the window because it was all
Well, but as my colleague pointed out, there's some basis to say it.
Yeah, but there's
event.
also some basis to say otherwise.
So that's why there's an issue of fact for trial.
Absolutely, Your Honor. And the Lopez versus 106 LPA, which we discuss in our brief, for example, with respect to the force generated, the weight, that was a 2-foot by 4-foot form used in concrete work that was left resting on its side at floor level against a wall, and it only weighed 50 pounds. As was mentioned previously, at page 249, 250 of the record, the plaintiff gave his estimate, as someone who works with these windows, that the window weighed between 225 and 250 pounds. We also cite a number of other cases where very similar types of weights and forces were considered by the court, where it was found to be a question of fact. There's also the Gregorian case, there's the O'Brien case. If I may very quickly...
You want to address the 241-6?
Yes, very quickly. First of all, I don't think that defendants met their burden in any way, shape, or form of showing that this was not a thoroughfare, passageway, et cetera, as far as the location where the windows were placed. The plaintiff's testimony was that it was on the way to this ramp that they were about to traverse. And also, an issue that I have with the interpretation of that regulation...
Let me just ask you this. I mean, the regulation says that they're located in an area that they shouldn't obstruct a passageway. How far were the windows from the dirt path?
I think there are questions of fact about that that can't be determined.
You don't know?
Right.
Your client didn't testify as to how far? Okay, let me rephrase.
I don't think he gave feet. If I'm not mistaken, I don't think he gave feet. And he said it was sort of near the top. It's very murky on this record where it was located, so I don't think you can say that. And I'd also point the court to the decision in Castillo, which also does not require that you have to be in a passageway or a thoroughfare, because the regulation has actually 3 parts to it. And one has to do with stability, it's the safe storage, stability of material piles, and the location. And in Castillo, the court also upheld it said that it did not have to be in that location. So that's not the only consideration, and we do address it in our brief, and
Thank you.
the 200's in our brief as well. I would rest on that. Thank you.
Thank you.
Just a couple of points, Your Honors. The testimony is clear. The plaintiff testified ad nauseum. Exhibit K, this is how the windows were. Yeah, you know, they were he said over and over, we leaned them 4 to 5 windows in a group leaning against the wall. He said it over and over and over. He was shown a photo. He said, yes, that's how the windows were. Secondly, the 2 cases relied upon by the trial court, Saraiva and Lali Shivi. There was testimony in both those cases that while transporting windows, straps were typically used in order to secure those windows. There's no testimony in this case about straps being used at this job site, and this window wasn't being moved anywhere, or being prepared for movement. It was stored. And as far as the Gregorian case, the fire pump that fell on the plaintiff in that case had not been touched by anybody. It was just sitting on its narrow end, unsecured when it fell. No one had touched. There's no evidence in that case that anyone had touched it before it fell. In this case, you know, the plaintiff, they have to pump these suction cups in order to fill them and secure them to the window. So they pump it full of air, and then when it comes time to release them, they press the button to release all that air. Different from the Gregorian case. Nobody touched that fire pump. Thank you, Your Honors.
Orlitzky versus 33 Greenwich.
Good afternoon. May it please the court. Tracy Peterson of Braverman Greenspun for the appellants. At the outset, all of the claims against the co-op are barred by the terms of the lease that required Mr. Orlitzky to give the co-op 30 days notice of the claims.
Was that issue raised below?
It was not, Your Honor.
And then is it a pure legal issue, or would there be some facts involved with respect to this claim?
All the facts that are needed to determine this issue are already in the record.
Has plaintiff been given any opportunity to demonstrate that he did send the required notice, or to address the lack of notice? Because it wasn't raised below.
So their arguments were made that at no time prior to bringing this action did Mr. Orlitzky raise any challenge whatsoever to the sublet letter. And it also was raised below that at no time after Loyal cleaned up the apartment did Mr. Orlitzky advise that there was remaining damage or trash to be cleaned up. Nothing happened, and then all of a sudden, this lawsuit was started. Even if paragraph 45 of the lease does not bar this action on the whole, all the claims—
We're not saying that. We're just saying it wasn't raised on appeal.
We're saying we shouldn't address it at all because it wasn't raised, and whether or not a notice is sent is inherently a factual question, not— usually when we say a legal question, it means it's just a legal analysis about something, but whether a notice was or was not sent is a factual question, so you'd go to look at the record to see whether a notice was sent, and that's something we don't normally allow on appeal to be raised for the first time. That's all we're saying, not anything about the merits of the argument. But why don't you go on with why don't you actually address the fiduciary duty?
I'm sorry?
Why don't you address the fiduciary duty cause of action?
Sure. So the breach of fiduciary duty cause of action should have been dismissed for a host of reasons. First of all, the relief sought in connection with that claim is an order requiring the co-op to consent to all future sublet applications.
But if you start with the proposition that the co-op is allowing others to sublet but not allowing the plaintiff to sublet, does that make out a claim for breach of fiduciary duty?
Well, not
Doesn't
on the
board
bare—
have a duty to treat him the same as it treats the others?
Yes, Your Honor, and all it says in the complaint is that there are buzzwords stating that he was treated unequally, and that was an allegation made upon information and belief.
Isn't this a pre-answer action to dismiss? It's not a summary judgment motion, so there's been no evidence, no depositions. So why isn't that sufficient for just a pre-action motion to dismiss?
Because 3016B still requires specificity in a pleading on a breach of fiduciary duty claim, and there is no required specificity here. There are buzzwords, and there are no objective facts pled that support a breach of fiduciary duty claim.
Thank you. You have time on rebuttal.
Thank you, Your Honor. So the breach of fiduciary duty claim stated against the board in the amended complaint is pled with particularity. It references the...
What's your claim with respect to that? What specific factual allegations are you making that the board breaches fiduciary duties vis-a-vis your client and the sublet policy?
Selective treatment based on 2 pieces of correspondence issued prior to the December 13, 2017 letter from counsel saying that my client could never, ever sublease again. There were 2 letters saying the board is reinstating its
was that done,
permissive policy for long-term subleasing, and then says my client can't do it.
Wasn't that done, at least there's some suggestion, and maybe it's not appropriate at this juncture, that your client wasn't paying the sublet fee?
So that would be something we could just have discovery on. I don't think at the pleading stage we can conclusively say that Mr. Orlitzky wasn't paying a subleasing fee and therefore is barred from the claim. Mr. Orlitzky, we actually pled that he did pay all the subleasing fees. In fact, what happened was...
Did you plead that he paid all of his fees? I didn't see that in the complaint. Did you actually plead that?
I believe it's in the complaint, but...
Okay. But did you plead that other tenants were permitted to sublet under similar circumstances to him and he wasn't?
We pled specifically that everyone else was allowed to sublease, that there's no evidence or any indication that anyone else was denied the subleasing, but most importantly, it's the long-term policy, which the co-op published twice and said, we're going to allow people to continue to...
Oh, there's a published policy for permitting subleasing.
Twice, in May of 2017 and December 2017, and then a month later, while the sublease is still extant, because my client was still allowed to sublease through August 2018. There's no dispute about that. So there was nothing before, like this issue of a 4-month period of limitations. We weren't challenging a decision based on a request for anything, whether subleasing or repairs or transfers, which if you look at, it's kind of,
So let's go back to the 4-month statute of limitations. What is your dispute with it? Because if it's a breach of the proprietary lease, clearly it's a 6-year statute of limitations. Right. But if in fact we're talking about alleged wrongful acts, bad acts of the board with respect to the third cause of action, implied covenant, wouldn't that be subject to a 4-month statute of limitations? Their actions as opposed to breach of the proprietary lease.
No, what we're saying, Judge, is that there was nothing before. So Article 78 applies to decisions by a body, where a body is asked to decide something and make a decision, and the statute or the courts have said, it's kind of a funny thing. Is it live or is it Memorex? Is it a breach of contract claim or is it a 4-month?
Well, but here, for example, you say that the board acted in bad faith because you did not send the letters to the appropriate California address, even though you knew the address. All that kind of conduct, isn't that subject to a 4-month statute of limitations for their actions, as opposed to something longer?
I don't think it's about actions. I think it's about whether there was something before a body that it needed to decide. My client didn't ask to renew the sublease in December of 2017. There was an extant sublease. That issue would arise the following year when the permitted sublease ended in August of 2018. I think the issue is whether, and counsel tries to characterize it and actually says in her brief that the 4-month statute of limitations applies specifically because this was a policy. When the letter was written in December 2017, this was a policy that the board implemented against my client alone. This wasn't a general policy. If a board issues an assessment or a board implements a new house rule, which is what the cases cited in the briefs talk about, and someone wants to challenge that policy against the whole corporation, then arguably you'd have a 4-month statute of limitations, but not when an attorney writes a letter out of nowhere and says, despite the 18, 19-year course of conduct where this subtenant was...
But again, counsel, those kinds of claims, if we preserve your breach of fiduciary claim, I'm just saying if, wouldn't all that fall within that breach of fiduciary claim? The conduct, the policy, and the failure to abide by the policy, treating your client differently, allegedly, than other shareholders.
We assert 2 claims that sustain the pre-answer motion to dismiss. The trial court sustained the claim for breach of the lease based on what we're talking about here, namely the decision by the letter from counsel in December 2017 saying my client could not sublease anymore, and the breach of fiduciary claim.
Did you comply with the proprietary leases provision with respect to sublets? Right? If subletting is denied, what's your recourse? What's your client's recourse? If the board says we're not going to sublet to your client,
the claims we interpose, whether breach of fiduciary duty or breach of...
Wouldn't you, under the proprietary lease, don't you have the right to bring the issue up in a board meeting of some kind, and then the shareholders will vote to make a determination whether or not to grant the sublease, correct?
So the provision that the court is referring to says in the event the subleasing is...
Did you comply with the provision?
Well, it's not clear what the provision, whether the provision requires my client or the board to bring it to the shareholders is not clear at all. But I don't think
Why
that's
would
a
the board bring
predicate.
it? If they've denied your request for subletting, it would seem to me that that's something that you would have to initiate.
Judge, that goes back to the issue of there was nothing before the board as to whether subleasing should be renewed or a new candidate was coming where they were looking at a new subleasing application. This was counsel for the co-op just in the middle of a sublease saying, after having 2 notices to all shareholders providing a continuation of a permissive subleasing policy, allowing everyone in the building to sublease long-term, saying 1 month later, you can't do this, sir, ever again.
The quote-unquote permissive policy that counsel refers to is very specific that it is still subject to the terms of the lease, which allows the board to withhold consent to any specific request to sublease for any reason or no reason. The record is entirely clear that at no time after the sublet letter was issued did the plaintiff ask permission to renew an existing sublease or to sublease to a new tenant.
Doesn't the proprietary lease give you the right to say no for any and whatever reason you want?
Correct, yes.
Right?
Yes, it does. That's exactly right.
And then what's the plaintiff's recourse under those circumstances?
The plaintiff's recourse is to put the matter to a shareholder vote. There's no allegation that he attempted to do so and the co-op prevented him from doing so. There is no claim for breach of contract. And frankly, trying to call this challenge to the breach of, this challenge to the sublet letter anything other than a challenge to board action is just trying to shove a square peg into a round hole.
Except it's not just that, it's that I'm the only one that they're doing this to. That's the problem.
Which she alleges upon information and
Okay, well,
belief.
but obviously, because he doesn't have the documents and the discovery that he needs.
He had 4 years from the issuance of the letter to do the barest due diligence. He did none. At no time after the issuance of that letter did he even test to see if the board was going to stick to its guns in that letter by saying, hey, you know what?
No,
I've
but
got a new
that's not the
subtenant.
point. The point is he's saying the board didn't stick to his guns or whatever else with respect to any other tenant.
The point is that
what
point
he's
is that he did-
alleging, counsel. Not that you didn't do, you had to do something, but that the board as a whole was singling him out. That's a pretty straightforward breach of fiduciary duty claim. It may not turn out to be good, right?
But he was obliged to allege it specifically per the dictates of 3016B, which he didn't, and he did it upon information and belief without setting forth the basis for that information and belief. In addition, that breach of fiduciary duty claim is entirely duplicative of the breach of contract claim, which we just established, I think, is non-viable based on the terms of the lease. Unless the panel has any other questions for me, we'll rest on our papers.
Thank you very much.
Thank you. Oh, and happy retirement.
Thank you.
The question that I have is, as an appellant, you take issue with the dismissal of your causes of action for breach of warranty, for breach of covenant of required enjoyment, for constructive eviction. But what allegations, which are here, and I couldn't find any, that establish that you have a basis for any of this? Because your client was in California all the time, with the exception of trying to visit after the sublet vacated and after the settlement of the holdover proceeding. So, I mean, what is here to support those allegations?
So I appreciate the question, Judge. The Andreas case that says a co-op shareholder has to be a full-time resident to avail him or herself of the warranty of habitability is bad law. It's just bad law. If a party is in possession of an apartment, they should have the benefit of the warranty of habitability. In the Andreas case, it looks like this court imposed a primary residency requirement for someone to avail themselves of the warranty of habitability. I think outside of the co-op
It has to
context.
impact your health, but thank you.
Thank you.
People versus Trowell.
Good afternoon, and may it please the court. Manvita Caparetti for the appellant, Mr. Ramzadeen Trowell. The question before this court today is whether Mr. Trowell should be released in September of 2025 or now. In March of 2020, inside a subway station, Mr. Trowell killed Mr. Rudolph Holloman Dunning. This tragedy, however, does not define Mr. Trowell's potential or his humanity. Looking at Mr. Trowell's traumatic childhood,
What was your client facing if you went to trial?
if he went to trial and was convicted on the top count, he was facing 25 years.
25 years. And what ultimately did he get? 6.5?
He got 6.5.
Oh, so it sounds like pretty favorable plea bargaining. And I'm sorry to cut you off, but you don't think the court took into account all the things you're about to tell us with respect to all the trauma that he suffered?
Yeah, so this was a good plea deal, but even a good plea deal can be excessive. And all of this information, you're right, it was in front of the sentencing court, but in every excessive sentence case, all this information will always be in front of the sentencing court.
Didn't your client waive his right to appeal?
The appellate, or the appeal waiver in this case was
And
not-
wasn't that appeal waiver basically exactly the model colloquy?
It was not exactly like the model.
Okay, what do you think is wrong? I mean, I looked at it, it looks almost exactly like the model colloquy. So where are you drawing the line?
So the model colloquy specifies if the defendant cannot afford the cost of an appeal or of a lawyer, the state will bear those costs. The court in this case did not mention that the state will bear the cost of a lawyer. It just said the appeal.
That's what you're saying makes the appeal, the waiver invalid?
That's one of the reasons.
Does it say that in the written waiver that he signed?
The written waiver says, I understand that the right to appeal would have allowed me with the assistance of an attorney.
Right, so it does say it in the written waiver. And you're saying that one phrase invalidates the waiver?
So, but I'll just continue. In the written waiver, it says, I am waiving that right to appeal as a condition of this plea. There's no further mention of counsel, that the defendant would still retain that right to counsel.
But still, it says with counsel, right?
Well-
So I don't, either are you taking issue with the written waiver itself, that no written waiver can ever be correct?
No, I think if this waiver had also specified that you would still retain the right to counsel even when you waive the right to appeal, then that would be fine.
The court didn't make up that written waiver, right? That's the
Right.
written waiver. So are you saying that all the written waivers that the Supreme Courts give out are all insufficient?
Well, the oral colloquy here was also insufficient, and that's why.
Okay, assume that the fact that you said your right to take an appeal and didn't specifically say, we'll pay for your lawyer. Anything else that was insufficient?
The timing of the waiver.
Okay, but we've already ruled on that issue. So let's assume that we're going to keep with our prior cases about that issue. Anything else?
I'll just specify that there was no mention of the appeal waiver by the court until after the factual allocation.
Right, and we've already had many cases on that issue. So other than that, anything else? So the one thing you're saying invalidates this waiver is the fact that the trial court said you're entitled to take an appeal, a free appeal, but not with a free lawyer. That's what you're saying invalidates the waiver?
That's correct.
Okay, thank you.
Thank you. Well, I'd like to continue with talking about Mr. Trowell's.
You have a few more seconds.
Okay.
If you want to use them, you can. You have
That's okay.
15 seconds left.
Good afternoon, Your Honors. May it please the Court. Noah J. Sexton for the people. To put it simply, if this isn't a valid waiver, I really don't know what is. When we're talking about the court and its colloquy not saying it'll bear the costs of an appeal and a lawyer, that's semantics. The matter of timing, there are several cases where you said that's not dispositive. In cases where everything else indicates it was a valid waiver, there was an understanding of the distinction between the trial and the appellate rights. There was an understanding of the general effect of the waiver itself. Here, he had a thorough colloquy, tracked the model colloquy in every sense. It was essentially verbatim, the model colloquy, with maybe one or two differences in the specific words.
The defendant had 4 prior felony convictions, so this wasn't his first rodeo.
Exactly. That's what, to the extent that the colloquy needed to be clarified, and really it was exemplary, he has this extensive history of pleading guilty in the state of New York. He had the written waiver, which was perfectly comprehensive about everything he was waiving, what he didn't waive. It left no room, really, for any questions.
And the court asked him, did you read that waiver? Did you understand it, right?
Yes.
And he said
gave
yes
him
and
the-
yes.
Gave him the
right?
opportunity to speak with his attorney before he executed the waiver and handed it up to the court. But even if, notwithstanding that valid waiver, to say that 6.5 years is an excessive sentence for a repeat felon who murdered a man in a subway, it's just, that's meritless. This was already, all the mitigating factors that he's bringing up, his difficult upbringing, mental health, physical health, all accounted for in the pre-sentencing report. And to the extent that it may not have been considered, it's already factored into how lenient this sentence is. There's just no world in which this is not an appropriate sentence or it's an excessive sentence by any means. And unless the panel has any questions, I'll just leave the remainder to the brief.
Thank you.
I'll just start by saying that the right to free counsel is very, very important, and it's so important that we don't want any defendant to not know of this right. So it needs to be very, very clear. And it's also important to remember that the totality of the circumstances here, we have the defendant who said on the record that during the plea colloquy, he felt a little off because of the medications that he was taking. He said that his kids were forcing him to take the guilty plea. And we know that he has a history of bipolar disorder and schizophrenia, so taking all of this into account, and the fact that there wasn't an explicit mention that you will still retain the right to counsel even if you waive your right to appeal, that shows that the waiver here should be invalid. And I'll also mention that the only reference, as far as the timing issue, the only reference to the appeal waiver was made by the prosecution before the factual allocation. And this court has never held that that is sufficient. And if that's no other questions, then thank you.
Thank you. Almy funding, U.S. Bank versus Almy funding.
Good afternoon. May it please the court. Christopher Volanti for the appellant. The order of the Supreme Court should be reversed in this instance amongst many issues here. The putative service at issue here is quite clearly on its face defective. This is a alleged service upon a limited liability company that took place via alleged delivery of papers on a doorman of a...
Before we get to the merits of the service and whether or not the service was proper, can you address the issue of whether or not the court had the authority to sua sponte raise the issue of whether or not you were the appropriate defendant?
Certainly, Your Honor. Obviously, our position is that that was inappropriate for the Supreme Court to do. The plaintiff at no time ever challenged the standing of the move-in in any of its papers, and that's Misicki. That's Court of Appeals. That you can't. Excuse me.
If it was inappropriate for the court to do that, why wouldn't the appropriate remedy for us as an appellate court to be to simply remand the matter to the Supreme Court to allow this issue, allow the case to go forward, or however it goes forward?
I mean, that's certainly an option for the court. I would again just then go back again to how clearly defective this service
No, I mean,
is.
you're saying it's clearly defective. The process server said, whoever the person was said, I am authorized to accept service. So you can't just decide that on the appellate level. You have to at least, at a minimum, have a traverse.
That's certainly a possibility.
I am saying to you, if the process server, as the process server here said, this person told me that they were an authorized agent to accept service. Even under the LLC law, that's good enough. Now, you may say that that's not true, but you can't decide that. We can't decide that on the papers here. You'd have to go back and at minimum do a traverse, right?
That is certainly a possibility. I would correct one thing. The process server did not say that this person told them that they were an authorized agent. If you look at the affidavit of service, it says it right on its face. I knew this person to be an authorized agent. There was no evidence ever submitted otherwise. This issue was raised in the papers on opposition to the motion.
So I'm just going to go back one step, because if the court below never made any determination one way or another about the service, how should we as an appellate court with such an incomplete record be making any determinations one way or another about even whether there should be a traverse hearing, whether the service was good or bad? Because there's no determination below as to service that's being appealed from. The only determination the court made is that your client didn't have standing. So none of those issues got decided for us to look at and evaluate whether it was decided correctly or incorrectly.
Certainly. This court has jurisprudence to the effect of when service is clearly, again, on its face, improper, that it doesn't matter who makes the motion, it doesn't matter if a motion was even made, that it warrants dismissal. I would point, we cited in our briefs, for example, Dubinsky versus Levine, where it was a default judgment, it came up on appeal, and this court ruled the affidavit of service, in that case, again, it was service on a doorman, it wasn't a corporation, but the issue was the affidavit of service didn't say that that the process server's progress was impeded, therefore it warrants dismissal. It's the same issue here. There's never been anything put forth. They had the opportunity in opposition, for example, to put a supplemental affidavit from the process server detailing everything that Justice Scarpool is asking, for example. That didn't happen. That is telling in and of itself. This is the idea that it's a reasonable assumption, even if, again, this person said they were an authorized agent, which, again, no evidence. The affidavit says he somehow knew it. It's not a reasonable belief that the doorman of a residential apartment complex in Manhattan, of a multi-unit residential apartment building where this defendant just happens to own one of the apartments, is an authorized agent to accept service of process on behalf of that limited liability company. There's nothing reasonable about that belief, even assuming that there was a misrepresentation, which there's no evidence of.
I don't know how we could make that determination here. That's what I'm trying to say to you. What if, I own the apartment and I put it in the name of an LLC, and I tell my doorman, you can take service from me anytime you want. We don't know what the facts are here. We couldn't possibly tell, based on an affidavit of service, that you are saying that we should look at whether or not that service was proper. We don't know the circumstances. It could be I just don't want that property in my name because I don't want anybody to know that I own this $10 billion apartment, or whoever it is. How could we decide that without the trial court looking at it?
So the trial court did have the opportunity to look at that and chose to make a sua sponte determination. However, it's not just the affidavit of service. There was a detailed affidavit presented by the principal of the entity that is the sole member of this LLC that went into great detail about not only the fact of who could accept service of process on behalf of this entity, but that not only this door person could not, but that no one even by the name of Susan has ever been employed by or affiliated with this entity. I would suggest there is clearly enough in this record to hold that the service was improper. There are many cases from this court with the notion that serving a doorman or a security officer to that effect is not proper service on a limited liability company, which requires strict compliance.
Thank you.
Thank you, Your Honor.
Good afternoon. My name is Gabrielle Menuza. I'm from Hinshaw and Culbertson for the respondent.
Counsel, you don't dispute that that there are any issues of standing, do you?
I don't dispute. I mean, I don't. Our position is that this party does not have standing.
Under Delaware law, isn't it possible for an entity like Almy Funding to have a series, a sub corporation, so to speak, with a series, and they can assert the things that the series would have been able to assert? So there would be standing, wouldn't there? Or am I misperceiving the Delaware law on this?
Your Honor, I don't believe that that's the inquiry here. From our position, whether or not they're legitimately a series and, under Delaware corporate law, I believe is beside the point, because what happened in this case was 4 years after the foreclosure was commenced and sale was being noticed, this party...
If Delaware law provides what we've just been talking about, so then wouldn't Almy Funding be in a position to come in and say, look, Almy Series, the named defendant, is really us, and we do want to raise, and we have standing to raise an issue about the service?
That wasn't done here.
But can I go back a minute? Because you didn't raise below that there was no standing, right?
Correct.
So if you didn't raise it below, even if we do end up remanding this case, why should the court below even make a determination as to whether there was not standing if you never raised that objection in the first place? Why should it even be addressed by anybody?
I mean, on the issue of whether or not the court was entitled to do that, it's our position, obviously, that they were, and I did cite to a case that cites to another case of the First Department that allowed a court to make a sua sponte finding on standing.
But doesn't this case highlight the problem with that sort of an approach? Because if, in fact, Almy Funding is Almy Series, how do you sua sponte raise the standing issue without anyone having a chance to put in any evidence on the subject or make any argument about it?
I mean, my understanding of the court's review was that this party came in at the 11th hour and then filed papers, the order to show cause, in a name that was not the same as the named defendant, and in doing that did not offer at that time any...
No, but you make it seem like you were like fighting every day for 4 years. You did nothing yourself for years. So the 4 years is on you. The 4 years is your issue, not the defendant's issue.
Well, the foreclosure was...
yes, it was 4 years, but you weren't doing anything during that period of time.
Well, the foreclosure was being prosecuted.
When did you get the order of reference?
I believe they received the order of reference in, I think,
2019. And when did you
they commenced the action in 2019.
Right. And when was the original default? And when, right?
Oh, it's because I'm sure you know.
Yes, I know. So okay, so you commenced the action in 2019, maybe 2020, you get the default, and you don't do anything for a number of years.
Understood. I wasn't handling
I'm
the
saying
case,
to you, the fact that it took 4 years was on your party, not the defendant. So if the court was thinking, you're telling us, oh, the court was thinking of itself, this party came in at the last minute. It's only the last minute because you didn't move the case for 4 years.
I think my point about that is just that, as if this party was aware of the case at whatever time they became aware of the case, it didn't happen until the very final stages of a foreclosure.
But that doesn't change the standing analysis, right?
In terms of the standing analysis,
I didn't raise it. Obviously I agree with that.
So shouldn't
but
somebody decide whether based on papers that everybody puts in and arguments that everybody makes, whether there is actually standing? Shouldn't the trial court do that?
I'm sorry, the trial court?
Don't you think the trial court should do that?
I mean, I don't think for what's on appeal at this moment, the necessary documentation and argument was made at that time.
Counsel, it's kind of like we want it both ways. You don't raise it, but now you want to you essentially waive it. And the court sua sponte picks it up, and now you want to run with it. And it seems, frankly, unfair.
My light is on.
It's not a question.
Okay.
Okay.
Thank you, Your Honor. Just with my brief time, unless the panel has any other questions, I do want to point out at least the one case that she mentioned that is cited for the proposition that standing could be raised sua sponte is this court's, I believe it's 2002 decision in Stark, which has been essentially universally held by other courts to have been essentially wrongfully decided or overruled because it was essentially premised on the wrongful assertion of really subject matter jurisdiction rather than personal jurisdiction.
That if we don't bite on your argument that we should decide the issue of service here and now, and we remand it, what is your position as to whether we should remand the issue of standing in addition to, for determination to be made fully briefed, in addition to the issue of service of process?
I think with what has been presented, even on appeal, that we've asked the court to take judicial notice of the operating agreement, it's clear that we had standing, so it's not necessary.
So do you think the court below should decide, should decide that issue with a fully briefed record?
I think we can, especially here, again, it's not just a standing issue. Also, the court sua sponte determined that we didn't even qualify as an interested person under CPLR 5015. And I think with not even without the operating agreement, which wasn't in the record on appeal, but even with what was presented, there was clearly enough evidence to show that we were at least an interested person with enough standing to make the motion under 5015A4.
Thank you.
Thank you, Your Honor. And congratulations on your retirement, Justice Singh. Thank you. Have a good day.